Hi, good afternoon. Can you hear me?
Yes, I can't see you though.
Okay.
I just have one. Okay, as usual, no audio-visual recordings allowed by either party. This time around, I will remember to switch it on for myself.
Recording in progress.
Then, can you hear me okay, Mr. Fernando?
Yes, I can hear you, and I would like to say something before you start or we start. That's okay.
Okay, but remind me, I do have a query to ask one of you after that. Yes, what were you want to say?
Okay. I want to say that I would like to revoke my statement and decision earlier to withdraw my counterclaim number 2. I think I was rushed to come into the conclusion without full understanding of Rule 19A. My understanding was flawed earlier in that I thought I could only claim for cost of time if another party was abusing or disrupting the tribunal process, which Ms. Gu is not. So after more careful review of Rule 19A, which was just presented to me this morning, I would still like to claim for item 2 for my cost of time. Because for me, Ms. Gu's claim was vexatious in that her claim is unreasonable, groundless, and of no legal basis, especially if you look at the handover form, which was signed and agreed as the final document. If the landlord had actioned according to the tenancy agreement and handover form, she should have returned the full deposit to me already. I strongly believe that were it not for Ms. Gu's vexatious claims, we will all not have to be here today. I will also not have to prepare the letter of demand and prepare and attend 2 consultations. So based on this, I would appreciate if, Dear Honor, you can consider my claim number 2 as part of your judgment and verdict as well. Thank you.
So basically you're saying it's frivolous and vexatious because it's very clear from the handover form that a claim would fail, is it?
Yes.
Your response to that, madam?
I cannot understand. I hold the deposit because according to 4QV that I can deduct the cost of the any destroy from the security deposit because we are still discussing how much we need to deduct from the deposit. That's why I hold the deposit from Fernando. This is the first reason. And the second one is Mr. Fernando would like to claim 5 days working day payment from me because he thought it is unnecessary for me to come to the court. Because we send information to Mr. Fernando that I would like to claim 5,000 from him and he didn't agree. That's why I came to SG court to claim for it. So I cannot see any problem with the procedure. And for 5 working days, I'm not sure whether whether it was supported by the legal in SG court. I'm not sure because I'm not familiar with the legal system in Singapore. But if so, I can also show some evidence that we operation the company and I spend money, I spend time, and my time we earn how much money in 1 day or 2 days. So surprise. Fernando gave us a surprise.
Mr. Fernando, apart from your salary cost, were there any filing fees that you had to pay?
There was a filing fee of $20.
And then transportation costs, like taxi because you said some hearings were physical, right?
Yeah, but the traffic or transportation was minimum. I think it's mostly my cost for my time. And just want to restate my claim again. I don't think Ms. Gu's claim has any legal basis, especially based on the handover form. So that's why I think the claim was vexatious.
Okay, what I wanted to ask, Madam, was you mentioned that you paid some money to the new tenant, right?
Yes.
Where are the documents showing this?
At your page at
Your bundles, eh?
page 46, the transaction record 46.
That's professional cleaner.
No,
The wrong one. Sorry.
sorry, the cleaner should be on 44 to 45, right? The new tenant refund is on 46.
Hang on, I'm trying to find the correct. You paid the new tenant 4,000.
Yes.
Is there any? That's the only document, is it?
Yes.
But do you have your new tenancy agreement?
Yes.
Does it state that you are meant to pay if he cannot move in on the 1st?
But we indicate that he can move in on February the 1st. And our apartment is not ready for move in, so I pay him the half month's rent.
But is there a clause in his tenancy agreement with you that says that you have to pay if he if you don't let him in by the 1st?
Good question. Because I think I indicate that the apartment. Okay, let me check. And for the clause 1, he can commence on February the 1st. Before February the 1st, should pay the landlord. Okay. We need to look inside the agreement, but the agreement is
So
that.
I think that probably, usually there is not.
But
so the thing is, like, if he can't move in on the 1st,
yes.
I thought the normal common sense thing would be is to just not ask him to pay for the period from 1st to 14th, since he cannot move in. So he does not owe you any rent, since the reason why he cannot stay there is not because he's on holiday, but because you didn't have the premises ready.
Yeah, because my fault. So I pay him the money. I think it's fair.
Okay, but if there's no, number one, I don't think it's within reasonable contemplation.
Mm-hmm.
Yeah.
Mm-hmm.
Even if there was a clause, right, specifically saying that in your particular tenancy agreement,
so
that
you mean
kind of payment is not. I don't know. Mr. Fernando, do you think it's like a reasonable contemplation that the landlord would pay if she promised that you could move in on X date and then you couldn't?
I don't think so.
Because I would have thought the normal thing is like the tenant just doesn't pay for that period, because the landlord acknowledges that she didn't have the place ready.
No, actually, he already paid for the first month.
Just refunded it to him now.
But that's my fault because he paid money to live in the apartment. And
okay, but it's different from you.
Because in my opinion, I signed the contract with the tenant, so I need to respect the agreement. I indicate that he can move in on February the 1st, but I cannot do that, so I pay back him.
Okay, I see. So it's your loss of rental.
Yes.
By not being able to earn 4,000.
Yes, loss of rental because we didn't.
Damages.
Yeah.
Okay. Understand.
Because the new tenant, he may.
Okay, I understand.
Okay.
Now I understand. It's because you refunded him. Okay. So just bear with me because now that there are Mr. Fernando said he wanted to claim, I have to change that part in my decision. All right. So I'll just give very brief grounds, which will be supplemented if necessary. As you both know, you already know the contents of your claim and your counterclaims and the computation therein. So I won't repeat that, even though I've written it down. I'll skip through the arguments since I'm giving the judgment today. You both already know what you've argued. I'll come straight to my findings. So based on the totality of the evidence and the party submissions, my findings include the following. Firstly, if I just look at the amount claimed for item A, which was the period until 1st of February, the January period, right, of the claim, I would say that no loss has been proven from 22nd of January to end of January, as the new tenancy agreement at the claimant's own motion or volition commenced on the 1st of February. So there was no loss, right, in that sense. Coming to the other items in the claim, I also find that the claim fails. I note that the claimant has relied on clause 4D and Q. In neither of those clauses is there specific mention of flaws, whereas respondent has pointed out clause 5C, which states that the landlord agrees to keep the roof, etc., and the floors in good and tenantable repair condition. So how do we read all these clauses together? Generally speaking, I would say clause 4Q cannot be relied upon by the claimant, as 4Q specifies certain conditions, right, about aircon and curtains. Yeah, none of those items, like from 1 to 4 or 5, however many they were, do not specify the floors. So clause 4Q is really specific to those particular items. Clause 5 would mean that the landlord would be liable, for example, peeling and cracking at the very least. But however, on the other hand, it will not give a blank check to the tenant to do anything he wants, because clause 4D would operate to place liability where a defect is not fair wear and tear. Okay, so that's just a general consideration of the clauses in the contract. Now I come to the handover document. The agent said that the handover document was subject to approval by the landlord. I missed something. I deleted something by accident. Oh, okay. Okay, so coming to the handover document, it evinces an agreement that if the developer repaired the floor, the respondent will not be held liable for its condition. As to the ambit of the clause, with the respondent arguing that it covers all liability and the claimant arguing that it only covers the repair cost of the floor, leaving her free to claim for delay-related expenses, applying the contra proferentum rule, the document is construed against the claimant as it emanated from her through the agent. So basically that legal rule says that where it's ambiguous and open to argument, right, the interpretation of a document, the maker of the document has it construed against her. So since the document came from the landlord's side, the interpretation is construed against her. In addition, the agent...
Sorry, can you just repeat that part again? I don't think I fully understood.
There's a legal principle which is called the contra proferentum rule. So that means that the maker of if there's ambiguity in the document, okay, the construction of the clause is construed against the maker of the document. So say, for instance, the company has a standard contract, right? And the two parties disagree, for example, what the seasonal mean, right? It's ambiguous. or whatever. Yeah, since the company says one construction and then the customer says a different construction, the customer's construction would prevail because, you being the company who created the document, you should have, made it very clear in the document in the first place what is meant to mean. Yeah. Okay, so now I come to say, the agent said that the handover document was subject to approval by the landlord and she had no authority to sign on the claimant's behalf. In support, she pointed to what she wrote regarding the holding on of the deposit by the claimant. However, that latter statement is not evidence in support of her proposition. Holding of the deposit could equally well have been instructed by the claimant anyway. And in any event, it suited the context in that both parties were awaiting the outcome of the developer's findings for decision on the flooring, right? In light of the circumstances, it was held out that the agent had authority to represent the claimant throughout the months of the tenancy, as seen by the many WhatsApp chats and evidence, and the agent's oral testimony that notwithstanding her claim that the handover document was subject to claimant's approval, she, the agent, had authority to leave one set of keys with the respondent on the handover date. She did say that although the landlord's approval was not written on the handover document, this was what had been agreed to by both herself and by the respondent. The respondent asked why she didn't write it down. She said that she had in her WhatsApp number 12. However, that WhatsApp message pertained to the developer and flooring and had no mention of the need to get the landlord's approval on the handover document. In this sense, the agent's oral testimony was hard to follow, owing to the way her answers seemed to be, not quite on point. In addition, assuming the handover document was otherwise, that is not in the respondent's favor, I would find that the claimant is stopped from holding the respondent liable for the delay in handover. This is because of the respondent's evidence that the agent had told him to wait for the handover to sort out the flooring issues, and I accepted his evidence. In her testimony, the agent said that she had told the respondent he had a duty to rectify the floor. The respondent said that he recalled her saying that in relation to other parts of the items in the premises, but not in relation to the floor. He gave his evidence clearly in a forthright manner, stating that in one of the viewings, he had inquired of the agent and she had said to wait until handover date, that on that date, the furniture could be cleared and the condition of the floor seen. His evidence was preferred over the agent's, as in contrast, sometimes the agent's evidence was highly subjective, as seen, for example, in the earlier example I cited when she said that her WhatsApp chat proved that the landlord's approval was needed for the handover document. And unclear or confusing. For example, when the respondent put it to her that she would see the state of the floor after clearing the furniture, she said she had no idea.
Which one?
Then when asked,
what is the number of the WhatsApp you mentioned?
It was number 12.
Okay.
Yeah. So also I'm pointing out that sometimes her evidence was also unclear and confusing. Yeah. So when asked about the state of the floor, she said she had no idea. And then when I asked her, does that mean whether she did not recall? She said no. And then she said she didn't update as the developer had not given a reply. So that was totally off the point. Eventually, the developer did respond, saying it was willing to repair free of charge around 27th of January. The works were completed in mid-February. What was the exact date that they were completed, actually?
Sorry.
What date were the works completed, the flooring?
12.
12th of February.
Yes.
Yeah.
Sorry, I think it was 10th.
No, because they asked me to
Sure.
leave the room alone and not get into the room because they just painted the floor. So the workers left on 10th, but they leave the room to me on 12th. They asked me to leave the.
So let it rest, is it?
Yes.
So the respondent pointed out that claimant knew that the works would take 10 to 14 days. Yet in spite of that, in the period coinciding with Chinese New Year, she had chosen of her own accord to start the tenancy on the 1st of February. In response, she said that the period until end of January would have sufficed for completion of the works, as Chinese New Year holidays need not necessarily apply to non-Chinese workers, and that the actual work took about 2 days with the floor left to rest for 8 days. This response is actually not in her favor because, if so, her duty to mitigate would lead to the conclusion that she had not sufficiently mitigated by not getting the rectification completed earlier. By the end of January herself. As the flooring issue was put on hold at the behest of the claimant through the agent, and the respondent accordingly did not take further action, and both parties knew rectification would take 10 to 14 days, I find on the facts that the claimant is stopped from claiming damages for delay in rental based on this ground. In any event, I would also find that the respondent has proven that the defective flooring was fair wear and tear. The developer's finding was accepted by the claimant, but there is no evidence showing that the respondent had agreed to be bound by the developer's finding. As explained by the respondent, the reason why the handover document was solution-oriented was because causation was not agreed upon. In any event, the letter itself from the developer just states the view that the scratches were caused by usage. So usage being usage, it does not determine whether that usage was fair wear and tear, which is a slightly different question. So given the photographic evidence from other units and the chats with other tenants, there was evidence that the floors were so constructed as to be easily scratched, and thus for this particular type of flooring, such scratching was fair wear and tear. The claimant's main concern was with the scratches. She accepted that the peeling and the cracks were damages that were not claimable. So respondent gave evidence, which the claimant did not dispute, that the scratches were about 1/5 or 1/6 of the floor, whereas the peeling or cracking was about 1/3 or 1/4 of the floor. As the claimant would have had to replace the flooring due to the defects that she concedes that the respondent is not liable for, meaning the peeling and the cracks, right? She has not proven any loss due to the scratches. So now so that means the claim fails now. Okay? In relation to the counterclaim, as the claim fails, then the tenant is entitled to have the security deposit returned to him. However, his claim for 10% interest fails, as although there's a provision for it in the landlord's favor for rental arrears, there is none in the tenant's favor for such interest. Okay, so such clauses need to be specifically put in if there's going to be such a high rate of interest. So I come to the rules as to costs. The respondent has submitted that the claimant's claim was frivolous and vexatious, as it was clear that she had no basis for it given the handover document. So in my view, the respondent is entitled to some costs, bearing in mind the other factors in Rule 19A, including factors mentioned such as whether it is just and equitable for costs to be awarded and proportionality. So having considered the circumstances, I would award costs and disbursements at $1,000. So the order is as follows. First, the claim is dismissed. Second, in relation to the counterclaim, the claimant is to pay $5,800. Mathematically correct, because the deposit is $4,800, correct?
Yes.
Then I said $1,000 for costs. By the usual is within 14 days. Is that okay with all parties? So 14 days would be what date?
14 days. From which day?
Today.
From today.
It would be May the 3rd, right?
14 day will be May the 3rd. Yes. Correct.
Yeah, so pay by May the 3rd.
Can I just clarify one point here? While I was reading through 19A, I see that in 19A4, he said any costs ordered under the Act must be paid within 7 days.
Actually, yes, you are right. So maybe I would just make everything all paid within 7 days. Any concern with that? Otherwise, it's not so great to split it like 4,000 by one date and the other one by another date. Okay, Miss Gu?
Okay.
So that would make it
April the 26th, right?
yeah, by April 26th. Everyone agreed on that date? Thank you for pointing it out. I forgot. 2023. Okay. So that's the decision. Just moving forward as a just some practical pointers that parties may wish to think of, because you will have future agreements with other people probably in future. So like for handover documents, sometimes it's useful just for the avoidance of doubt to say like it's in full and final settlement of any disputes as to what defects there are at the date of handover, for example. That kind of thing.
Sorry, can you repeat that? In the handover form, what should we do?
Well, number one, as you've seen, the agent has said she's not the agent for the purposes of handover. So one thing, I mean, I've never encountered this before. So one thing is to actually, verify and have it in writing that this agent is signing off for the landlord for the handover. Do you get what I mean? Yeah. I mean, this is just practical points. And for example, like saying, and this protects both parties, right? So it applies to both, like, to say that these are the defects and it's agreed that that's it, full stop. No other defects after this date. You get what I mean? Sorry, I mean, there were other things that I happened to think of, but I just can't remember offhand. But I mean, it's something useful for both landlord and tenant to keep in mind.
Okay, well,
and so like I think your agent is also a bit unclear about, when she's signing for herself or signing for the landlord. So, I mean, for that, you want to make it clear in your contract, or sometimes you just want to read your tenancy agreement and look at the wording to see how you want to protect yourselves, whether you are the tenant or the landlord. And then just change and vary it by signing off together wherever the terms are varied. Okay?
So will I get the final decision in written paper?
I will put it in the system so it can be downloaded from the system.
Okay, when?
Well, I'll probably try and do it, but I'm not sure. Should be by at least Monday.
by at
I mean,
least Monday.
Normally I do it straight away, but I've got some other things to do, so I may not be able to complete it in time. It was a bit of a, I had to.
Understand.
Okay, but it should be soon. Lah. At least the final order, I think I can probably put in soon today. Lah. Okay?
Thank you very much for the pointers.
All right.
Thank
Good
you
day,
for your
everyone.
time today.
Thank you.
Thank you.